Good morning. This is Senate Judiciary, and I apologize profusely for Bennington, but I wasn't able to get people to be here this morning that are usually here. So I'm in Bennington, you're all in Montpelier, and Eric. So Eric Fitzpatrick is going to walk us through H546, an act relating to racial justice statistics. And as a bit of an introduction, part of this has been around before, but given the Justice Reinvestment 2 report, the final report this January from the Justice Center, indicating the number of persons of color who are incarcerated in Vermont, it seems more timely than ever that we have a good understanding of justice statistics. And part of what held the Justice Reinvestment 2 and the working folks from the Justice Center who are used to going into states and delving into statistics was the lack of statistics in Vermont. We just haven't done a good job. And so that's why I think this bill is fairly important. But I will let Eric walk through it. It's all of 12 pages. And feel free to interrupt Eric and ask questions if you have them while we're walking through. So Eric, take it away.
Yes, thank you, Senator Sears, and good morning, everybody. This is Eric Fitzpatrick with the Office of Legislative Counsel here, as Senator Sears mentioned, to walk the committee through H546, which is an act relating to racial justice statistics. A pretty lengthy bill with all new language, or for the most part, new language regarding this topic. And as Senator Sears mentioned, this is not brand new to the committee. You may recall that this has been a topic that's been discussed several times over the last couple of years. It originated back in 2019 when the Racial Disparities Advisory Panel, RDAP, first recommended in their annual report that for the reasons that Senator Sears mentioned, the lack of data, the lack of statistics, the creation of an entity in state government that would be responsible for collecting all this data and working with law enforcement agencies and the other players in the subject of criminal justice to serve as a repository and be able to make policy recommendations based on the data, that sort of thing. But then last year, so that was the 2019 report, and you may recall then last year, it was discussed. There might even have been, I think there might have been a joint meeting between the House and Senate Judiciary committees on this last year. And the bill was moving along, but the topic that the interested parties were struggling on was sort of governmentally, structurally, where to house this entity. I think everyone agreed that the need for the entity was there. But I think the debate was, sort of boiling it down to, should it be in state as a part of state government and have the advantages of having the administrative support, the logistical support, the other entities of state government that could work more easily with the entity, but maybe not be totally independent, or should it be a freestanding body that was independent of government so that it would have the necessary independence to work without any sort of political influence? And that was the debate that was going on last year. And then as a way to move the ball forward, you remember actually it was in the miscellaneous bill last year, S97, that what you passed was some further instructions to have RDAP go back and relook at that issue and come back with a recommendation this year. And so they were tasked with, all right, this is the issue that's hung everybody up. Where are we going to put this body? Go think about it some more and then come back with a recommendation. And that's what they did. And that's what H546 embodies, what this final recommendation was as to where to put it, and some of the other details, of course, as well. Although some of them might seem familiar. Some of the language of the details is similar to the legislation that that you were looking at last year before the issue of where to put the body kind of slowed things down a bit. So that's the background. And the bill, as I mentioned, is pretty lengthy. Senator Sears, I think probably everybody has a copy, but I could also pull up the screen if that would be easier, whatever you think would be the best way to do it.
I've got a copy, so I don't, it's probably
We've got
easier to
copies
just,
too.
okay, why don't we just go over the bill?
Okay, sounds great. So right on the first page, the very first thing that is being laid out there is exactly what I was just describing, which is the structure of how this entity is going to be housed and where it's going to be. So the proposal that RDAP came back with, and which is in H546, is that, you know, the existing executive director of racial equity that exists now within the agency of administration. So the proposal is to have the new, what would be called the Division of Racial Justice Statistics, DRJS, Division of Racial Justice Statistics, would be housed within a new Office of Racial Equity alongside the existing executive director. So the ED of Racial Equity, which you have now, would have some supervisory and oversight authority over this new division. And they would be, as I mentioned, alongside each other, both within the agency of administration. So they both would have the administrative support, the logistical support, hopefully, you know, and there's been some discussion with the administration about this, even the physical space issue, you know, so where to put the folks. And that's also something that the agency is, I think, hopefully going to help out with. But yeah, those are all.
Go ahead, Jeanette.
Yeah,
Can I ask you a question?
yes,
I
please.
don't understand reading this, the relationship between the executive director and the Office of Racial Equity and the director of the Racial Justice Statistics. I don't understand the relationship. Is it that there's an Office of Racial Equity? Is
Right.
it underneath there? So is it underneath the executive director of Racial Equity?
You mean which one underneath? So you have, I think the overarching entity is the Office of Racial Equity.
Yeah.
That's the big office. And then underneath that office, you have the director, Susanna, the existing director, and this new division. And they would be alongside each other, both underneath and within this Office of Racial Equity. But the director, the existing director of
So
racial equity.
they're on the same level, the executive director. It isn't a division within there, and if she's the executive director of the office, how can there be a director of the division that's on the same level that she is?
Oh, right. I'm sorry. She's not the executive director of the office, I don't believe. I'm sorry. Yes, you mean the Office of Racial Equity, right?
Yeah, she's
Yes.
the executive director of the office. So you
Right.
have an office with an ED, and underneath that you have the Division of Statistics, right? Underneath the office and underneath the executive director.
Yes, and that's why the executive director has this supervisory /
Okay.
oversight.
So-
You'll see in that first language there, they have this, the ED has this ability to, or sorry, not authority to appoint employees, apply for grant
No,
funding.
But that's
you
the
know, that sort of-
director.
Senator Sears is trying to cut in there.
Okay.
Okay, Eric,
Senator Sears.
who is the director? I think that's the question.
Oh, I
The
see.
first
Yes,
sentence
that,
Is
That
the
means the
direct, is it
executive-
the director of the division or the director of racial equity?
racial equity.
Okay, perhaps
Also-
we should put that in there. The
I think it
director of,
should say the executive director of
Executive
racial
director.
equity.
Yes, that's who that means. That's who that's referring to.
maybe we should
Okay.
put that
I
in
think
there
it should be
since,
clear. Yeah.
Yeah, that could be, and you'll see that like on the first page, the non-underlined language new subsection F, director is what, we just use director because that's what the existing statute is. But you're right, because of the new sort of additional layers here, it might be clearer to say the executive director so that there's no confusion.
Yeah.
Yeah.
Yeah, thank you.
And Eric,
Where does he talk?
Yeah.
in the next line, it says the director may appoint employees as necessary. I'm not sure if that's just boilerplate language. It sounds very expansive. Does that mean that the executive director can move people within the office, or does it mean that they can just appoint people and hire them?
And create new job.
That's a good question. I'm not really sure, and that segues me into a little bit more background about my role with this bill. It may immediately strike you that this is, in many ways, government operations subject matter here, and so the initial draft of this bill was actually done by Ameren in our office, but she got busy, as you know, with redistricting. So I've taken it over for quite a while, but some of these questions I might be able to redirect to her, or you could have, and one of your witnesses, I'm sure, will be the current executive director, so that she might be able to provide some background as well. But as far as that appointment authority that you were referring to, Senator Baruth, I'm not specifically sure whether that means, I know the current, we'll get to later on in the bill, you'll see that there are specific positions that are created. Whether this also means the authority to create additional positions, I think you have to do that in statute.
Yes.
But I'm wondering why that language is necessary, because all, commissioners and secretaries have a power to move within their employee system. But this language sounds as though appoint employees as necessary. It sounds as though that's a kind of novel power that I haven't ever seen before. So that's a red flag for me.
And she only has a couple of people. How can she move them about?
Right, but I mean, under that authority,
Yeah.
could she say, I really need a third and fourth person, I'm going to appoint them, and then the legislature is obligated to follow up?
I think that those 1 and 2 need to be clarified.
Yes, I will. I'm noting that right now, so I can follow up with Ameren about that and see what the original intent of that language is.
Yeah, I mean,
Sorry, go
you can
ahead.
only appoint what you have funding for.
Right.
And the funding comes through the appropriations process. So it sounds like she can do it, but sort of like, how do you pay for it?
Can I ask a question out of ignorance, because I'm not on the appropriations committee, but this says that she can apply for grant funding. Does all grant funding come through appropriations, or are there external sources?
Basically goes through the Joint Fiscal Committee. The administration applies for grants, and the grants have to be approved by Joint Fiscal. And then if there's a question, they can be held for a Joint Fiscal Committee meeting. But I know lately there's been so many grants that we just routinely approve them. The federal grants for example, the storm that created problems in Windham and Bennington counties, there was a grant from Homeland Security for that, and we pretty much routinely approve those. The administration has to go through us or through the Joint Fiscal.
The administration.
They sends a grant notice out.
Yeah.
One of the bones of contention is sometimes they spend the money before they send out the notice.
I'm just looking at how that dovetails with the previous sentence. And,
Well, I think it's okay, but maybe it's Joint Fiscal should look at that. Both 1 and 2, E1 and 2.
Yeah, it seems to me that what you're trying to say here is that they can apply for grant funding for this, and then I would assume that with a grant, you're hiring a limited service employee to carry out the functions until you need to go to the legislature.
Usually
position.
the grants are time sensitive, so it's like
Yeah.
3 years or 2 years
Yeah.
or whatever.
And you would do a limited service position.
I just don't want there to be a way to bypass the legislative process. If
Yeah.
she's given the power to appoint as necessary, if she decides she wants X, Y, and Z, and happens to come up with a funding source, does that bypass the system?
I would ask Eric if you could just run this by somebody at joint fiscal.
Yes.
It would go before the joint fiscal committee. I get notices all the time whenever Department of Public Safety or anybody like that applies for a grant. I get a notice that says, we've applied for this grant. It's this much and it's for this purpose.
Anyway, why don't we go ahead? F and G are just
Yeah.
Existing, right?
existing, so.
Yep. Yeah, and I've noted that. So just sort of keeping in mind the concept that the
I've got to go
director has
help
authority.
somebody if Senator Baruth could take over for a few minutes.
Sure. Go ahead, Eric.
Okay, thank you. So yes, the executive director does have this sort of general oversight authority over the new division. That's the structure. You also see when we get to it, just going to note before we get to the language that you'll see later on that another body that's created is called the Racial Justice Statistics Advisory Council. Now that's sort of patterned on structurally that what also exists right now. The executive director of racial equity also works with what's known as a racial equity advisory panel. So these advisory panels sort of work as policy recommendations. They look at the data that is forwarded to them by the body with which they are working. In this case, it's going to be the Division of Racial Justice Statistics. That division is, when you'll see the positions, they're IT positions primarily. They're people that are working in the information technology field. So the advisory council you'll see is set up to have a policy recommendation role and to analyze the data and sift through it that the division itself creates. So just to sort of forecast that for you before we get to it.
I realize we're not there yet. Can you just clue me in on the thinking? It seems at first blush, it seems duplicative to have one advisory council, one advisory panel. And as I look through, it doesn't seem like the advisory council are experts. They're members of the community who would weigh in from different segments of the community. But if in my memory, the advisory panel is the same. So what was the thinking behind not just using the existing advisory panel?
Yep, absolutely. Yep, that certainly came up. And I think the ultimate where they landed was that because of the specific task that the Racial Justice Statistics Division has. In other words, that the executive director and the RDAP panel and the other advisory council that works with the existing executive director, have a much broader mandate. They deal with a much broader range of topics, and that it was important to have an advisory council that was very narrowly targeted to this racial data issue, as is the division itself. And that's where they landed as far as the reason to have this separate body. But you're right, it's a legitimate issue, and it was the same issue was discussed, and that's just where they came down.
Okay.
So I think that, our conversation about them applying for grants and the appointing people, I just zoomed ahead to the end because I couldn't stand it. And there's $4.2 million appropriated to this division. So just so that we know, it's
Ongoing, like
4.2.
every year.
I don't know. It just says 4.2. It doesn't say that
No.
it has a,
No, it's not ongoing because about half of it, if you want to skip, we can certainly look, if you want to, it's hard to, sort of like reading the last chapter, right? You want to find out how it
I
ends.
know, but I really needed to know if they were gonna appropriate money here because she has, I think, 3 people in her office and she can't move them around, but there's a lot of money here for per diems for people and agency of digital services, which makes a lot of sense. So anyway.
Yes, that's the one-time money. Is the
Okay.
520,000 to Agency of Digital Services is one time because they testified that they would need that money to get the data infrastructure up and going, but that that would be done during the first year, and that after that, presumably they'd be all set and they wouldn't need it anymore. So the ongoing money is the 363,000 for the staff people and the office space. That's based on a joint fiscal office note that Stephanie did. So that's where those numbers came from. Actually, all the numbers are based on JFO.
Is the 3.3 million, is that one time, Eric?
Which one?
That's for per diems for the advisory council, $3 million?
No, it's 3,000.
3,360.
Oh,
Yeah.
got my,
Those would be some pretty.
I was gonna say, my God, those got a lot of people there. Okay, I feel better now.
Okay, so it's basically $366,360
Every year.
is base, right, is every year. And
Yeah.
the 520 is one time. Okay. Well, now that we've looked at page 12
Sorry.
or 11, can we go back to page 3
Sorry.
or wherever you were?
Yes, I think page 2, actually. So now we talked about sort of where it's structured, and now we move on to subchapter 2, which is sort of, again, that's the statute is sort of mirroring the structure of the bodies. Subchapter 1 was the executive director, subchapter 2 is the division. And so this division, as I mentioned, is created in the agency of administration. Subsection 8 creates it, describes what its purpose is, and gives sort of a broad mission statement and articulation of its overall purpose. So you see in subsection A, that's where it says, well, what's this division doing? It's collecting and analyzing data related to systemic racial bias and disparities within the criminal and juvenile justice systems. Now that language should seem familiar to everybody. That's very similar to the language, if not identical, to the overall purpose of it that you were looking at last year. So that hasn't really changed. There's some specifics added on in subsection B about what's the purpose. It's to collect and analyze this data with the intent to center racial equity throughout the efforts. So to keep that as your overriding purpose, is racial equity while you're collecting this data. The purpose, again, is explained further to create, promote, and advance a system and structure that provides access to appropriate data and information, ensuring that privacy interests are protected and principles of transparency and accountability are clearly expressed. And then the last sentence in the purpose, which is important, is that the data are to be used to inform policy decisions. So the idea is that this data isn't just sort of collected and left alone. It's to inform policy decisions that work toward the amelioration of racial disparities across various systems of state government. So that's, as I say, a broad statement of the mission and the overall purpose of the division. That's in section 5011. So then you move on to section
Eric,
5012.
can I ask you a question first?
Yeah, please do.
What does it mean to center racial equality? Should it be centralized, or what does that mean with the intent to center racial equity throughout these efforts?
Stole my question.
What does that mean?
I will defer to some witnesses to provide you more detail about that, but I will say that is a term that is now used, center, to means to, pardon me?
To bring it out of the margin to the center.
Yes, thank you. Exactly. It's sort of a term that's sort of become more commonplace recently.
Okay. I think it's a dumb term, but nevertheless.
I understand it.
And I don't think anybody reading this would have any idea what that means, except an academic.
Ouch.
Ouch.
Which is right. Well, let's move right along to duties.
So from this broad mission statement, we now move to the more specific duties being laid out, and that's in section 5012. Really, the most important one you'll see right in the beginning, particularly the first one. It's that the division is going to work collaboratively with and have the assistance of. That's an important phrase right there. And have the assistance of all state and local agencies and departments for purposes of collecting this data related to systemic racial bias and disparities. So you'll see what that language means is that all state and local agencies are required to assist the division and required to collaborate with the division on the collection and provision of this data.
I'm going to ask Bruce's question before he asks it. What do we do if they don't?
There is not a penalty or a consequence mechanism in here for that. So it is a requirement.
I think that's important. I can remember in a bill, Senator Baruth put in language, or suggested in the committee adopted the language that there was, you couldn't get state and money if you weren't keeping proper statistics and that sort of thing. So I think there are those who will deny and may not keep that information or not provide it.
Can I add a comment on that? There are DPS is working really hard with all the local agencies around the collection of data, and they've all gone to use the Valcor system now. So everybody is using that, and they're all collecting pretty much the same data with the same identifiers. And out of 73 agencies, 71 are already collecting the same data and giving it to the department. So it is happening. 71 out of 73 are already complying.
Can I ask, Eric, so it says collecting all data related to systemic racial bias and disparities within the criminal and juvenile justice systems. Is it up to the office, the executive director? Can the executive director just unilaterally lay out the fields of data that people must provide? Or do those have to be run through the legislative process? So for instance, traffic stops, we require data, but could the director create new categories, and then this binds everyone to provide whatever that person, the director, asks for?
The answer to that is that legislation is not required, but the executive director, or I should say the head of the division is you'll see is referred to as the division lead. So just so I don't mix up the terms, I'll try and refer to that division as the lead, and the executive director refers to the existing executive director position. So the reason I say that is because, and we'll get to this, the specifics of how that data is solicited from the state agencies, but the general approach of how it works is that the executive director, the division lead, and the advisory council that I mentioned all work together to develop the list of the data that these agencies are going to be required to provide. And then that once they develop that list, then they solicit it from the agencies, and the agencies have to provide it. So that's sort of the general description of how it would work. Now they could do it. You'll see we get to this too. The division is provided with rulemaking authority, so that the division could, and this is an interesting bit of background, the way it's phrased now, the division may adopt rules, and they would have to go through the LCAR process. So the legislature would have their oversight role in that respect if they did do it through the LCAR process. But it's discretionary. In other words, they can develop these things by rule, but they aren't required to. And that was a point of discussion in the House for a while. The rulemaking was mandatory, and they for precisely in part for the reason that you mentioned, Senator Baruth. And they discussed and debated that point and just landed on the side of having the rulemaking be discretionary for the reason that there may be some things that because of the time consuming nature of the rulemaking process, that there may be other elements of it that the division might not want to adopt through rule. So that's just a little bit of background to sort of explain where that came from, but it's certainly the idea is.
Oh, go ahead.
I'm just going to throw in this comment that we in government operations have done a lot around collecting, law enforcement agencies collecting data and what they're supposed to be collecting. And there is a list that they're supposed to be collecting, and they were very clear, and we might hear it here too, that you don't want that list to be defined in legislation, because legislation takes so long. So that if there's something that they say, oh my God, we didn't get this in the bill, and this is something we really need to be collecting, it's better not to put the specific piece of data that they're supposed to be collecting in the legislation.
And I can see that, but I'm thinking about it from another angle. Suppose the new list comes out when we pass this, and it's extremely expansive, like 100 data points that need to be collected that have never been collected before. Just to pick an example, they might suddenly find themselves complaining, we can't do that in the way that I'm thinking about in the Ed Committee. Anytime you add one piece of data that has to be reported, you get complaints all down the line because it's intensifying their bureaucratic performance for Montpelier. And I'm just wondering if this office has the power to unilaterally generate the list, as well as in this draft, the power to appoint as many people as necessary. It seems like it is moving toward a very expansive view, and maybe having LCAR involved or someone else isn't a bad idea before those are made mandatory on all the agencies. But I just flag it because there are a number of things about this setup that seem to me as though they were left at a large sort of slightly shapeless form, and then there's going to be a little bit of tightening. So it seems like there are 2 or 3 areas where we might tighten without doing anything to prevent what they're trying to accomplish. So.
Can I suggest that we move along?
Sure.
We're only on page 3 and we've got about 20 minutes left. So if we don't make it through the bill, we can come back to it next week, I guess.
Sure. So, and I've noted a couple of the points there about the assistance from other state and local agencies that we've just been talking about. But moving on from there, you'll see some of this list is pretty straightforward. These are the duties, the specific duties that division has. Moving on, number 2, collect and analyze this data that we're talking about that's related to systemic racial bias and disparities. Number 3, conduct justice information sharing gap analyses. In other words, where are there gaps, where are there holes in the sharing of this data back and forth between agencies. Number 4, maintaining an inventory of justice technology assets and a data dictionary. Data dictionaries are these sort of centralized repositories of information about data. Sort of maintain that structure as well. Develop a justice technology strategic plan you see in subdivision 5, and they have to update that annually. So they got to have a strategic plan about justice technology. Number 6, they got to develop interagency agreements and MOUs for this data sharing and publish public use files as well, so the public can look at this. You'll see that transparency is an issue here. And they have the reporting, couple of reporting requirements. You'll see in subdivision 7, first of all, they have to do a monthly report to the advisory council that I mentioned earlier. So there's going to be this advisory council that works with them to develop policy, recommendations, that sort of thing. So as the division itself collects the data and analyzes it and makes its own recommendations, it's got to be in touch with the advisory council. So it envisions this relationship. So every month they have to provide this report. Then annually, you'll see that moves on to subsection B, very bottom of page 3. Annually, they report to the legislature. So they report its data, analysis, recommendations to the legislature, this committee, the Judiciary and Government Operations Committees every January. And you'll see that the advisory council that I mentioned also has an annual reporting requirement to the legislature, and we'll get to that toward the end. So those are some of the specific duties. You'll see then over on page 4, I mentioned the rulemaking. That's subsection C. See, so that provides the division, but you'll see the terminology right now is may. At one point in time, it was shall. But so that's a kind of goes to the part of the point that the committee's been discussing. But right now, as it passed the House, they landed on may. They may adopt rules in accordance with Chapter 25. That's the Vermont Administrative Procedure Act. So that means the rules would have to go through the LCAR and the rulemaking process. So those are specific duties with regard to collecting the data. We're now getting on to, well, what do they do with the data, the data governance, the rules of, and language about, well, what they're going to do once they have it. And you'll see, as Senator Bruce, this is specifically the language in response to your question is right there in subsection A. So what gets collected and who decides what gets collected? You'll see it says in consultation with RDAP and the advisory council. I'm sorry, I misspoke. It was actually RDAP that's also involved in this decision about what gets collected. So in consultation with RDAP and the advisory council, the division shall establish the data to be collected to carry out its duties. So these entities consult with each other and they decide what data, necessary to understand the racial disparities in the criminal justice system, which data needs to be collected, and they have to establish it. I'm going to skip for a second because there's a public records issue in subdivision 1, but just because it logically, just to the next 2 paragraphs, 2 and 3, just because, or at least subdivision 2, because it's sort of flows better from what we're just talking about. So they work. So we'll go to the top of page 5, subdivision 2. We just talked about how, all right, the division has to work with RDAP and the advisory council to identify what data gets collected. Then what? All right, subdivision 2 says, well, next step is division then has to identify which agencies and departments have the necessary data. That's the first sentence. So they do this identification, who's got the data. And then the next sentence is, all right, what if an agency is identified? So they're on that list that the division comes up with, hey, you're this Department of Public Safety, this Sheriff's Association, local police department, whatever it is, whoever's on the list. If they're identified, the agency has to provide the division with any data that the division determines is relevant to its purpose. You'll see that's in the second sentence. If you're identified, upon request, you have to provide them with data that the division determines is relevant to its purpose. The purpose being, there's a cross-reference there because that's what we went over in the very beginning, what their general purpose was. Now, there's an exception there, you'll see, for the Office of the Defender General. That's a specific, specifically there in statute to address the fact that the Defender General has unique attorney-client relationships that could be impacted by a requirement that they divulge data that could inadvertently compromise the attorney-client relationship and their requirements to keep the information confidential. So there's a specific exemption provided to this Public Records Act issue for records that if, and that cross-reference exemption in Title I is for any records that if made public would cause the custodian to violate ethical standards for any profession regulated by the state. So the DG requested that exemption, and we worked on the language to have it cross-reference the correct piece of the Public Records Act, and that's why that's there.
Eric, can I ask the question?
Please.
On 2, it says the division shall identify which state agencies or departments possess the data. But it
Right.
doesn't say anything about which local agencies or departments might possess the data. And isn't that in conflict with page 3 where it says all state and local departments have to comply? So shouldn't that read all identified state and local agencies and departments? I mean, because
Yeah, I
you
think
look
that's
at-
the intent. So you're right. Yes, that it is the intent. So if it's not being made clear, it should be. You're right, Senator White. Thank you.
Yeah. And it also doesn't say here which, that they will identify local departments or agencies and local entities that might have the information required. Doesn't address them at all here.
Well, it would if it added the word local.
Right.
Yeah,
Yes, I've jotted that down right there. So that's right. That's with the intent. So it should be local as well.
and it should on page 3 say identified agencies instead of all state agencies and local departments.
Well, I thought page 3 did say local. You mean subdivision
It
1?
does, but it says all state and local departments. And then on page 5, it says those who are identified. So
Oh, right.
on
So-
page 3, it should say all identified state and local entities.
Oh, I see what you mean. Right.
Yeah.
Yep. I might even want to say identified pursuant to, and then cross-reference
Yeah.
that statute.
Yeah, that's good.
Yes, thank you. Good point. So yeah, the last, back onto page 5, that very last sentence too, also, we were talking about state and local. There's also a sentence about non-state entities. So if they can enter into an MOU or an agreement with a non-state entity, then they can access the non-state entity's data as well.
So there's not a legal requirement that the non-state entity participate. They only do so if they want to finalize an MOU.
Yes, I think that's right. You can't necessarily require them to do that unless you impose some kind of statutory penalty.
Yeah.
Well, we do have a penalty now for if a local law enforcement entity does not follow state policy, or if they don't do what they're supposed to do, they can't apply for grants from public safety, and they can't participate in the functions of the academy, which means they can't send any of their officers to be trained at the academy, which means they're out of luck. So if they don't comply with this, if this is a state policy, they won't be able to access the academy or apply for grants. That's already in law, in
Right.
current law.
Okay. Where are we?
So just jump back for a moment to page 4, just that last piece I skipped for a second. So this now has to do with the public records effect of this data being transmitted to the division by the state and local agencies. So the general principle here is that, because this was another issue that was discussed, how does that impact the Public Records Act? So where it landed, and I worked with Tucker, who's our public records attorney, quite a bit about this to get the language right. And the first sentence basically says, if and this is the policy they landed on, if any records that are transmitted, because you think about what's going to happen, the division's going to be asking state and local agencies for data and records. So if the data or records are exempt from the Public Records Act in the first place, in other words, if what they're asking for is exempt, then they remain exempt and shall be kept confidential to the extent required by law. So in other words, the transfer of them from the state or local agency to the division doesn't change their status. If they were confidential before, they remain confidential. So then the question becomes, all right, well, what if somebody requests them? How do you respond? And so what the next sentence says, all right, the transmitting agency whoever sent it, they remain the sole records custodian for purposes of dealing with these public records requests that may come in. Next sentence gives the division some discretion, though, because you'll see that you think about it, there's going to be two different sets of information. The raw data that they get from your local agency and other data that the division comes up with itself, or other conclusions, or other assimilated data that the division comes up with, which is different than the raw data. So what the next sentence says as well, the division remains the agency who's going to respond to this non-identifying data that they come up with, that they collate. So they would be the ones who would respond to those sorts of records. So that's the idea there.
Okay.
All right. So now we're moving back over. We're getting toward the end of page 5, and so I think we're getting through the bulk. The bottom of the stuff is going to be, I think, move a little more quickly. So we're now subdivision 3 of page 5. It says the divisions, well, requires them to establish and maintain a management program for its data, and it does that with the support and services provided by the Archives and Records Administration and the Agency of Digital Services. Both of those agencies, under existing statute that's cross-referenced there, they already provide that stuff to state agencies. They're required to. So that's just making it explicit, but it's already in law. The division also has to, so now we go on to, all right, they've got the data, they got to analyze it. That's subsection B. All right, what they're going to do, they analyze it so they identify the stages of the criminal and juvenile justice systems at which racial bias and disparities are most likely to occur. They organize and synthesize the data in a cohesive and logical manner. They have to present it to the advisory council. Remember, I mentioned they have a monthly reporting requirement, so it has to be presented to the advisory council every month. Subsection C, they have to also adopt a data governance policy. How is it governed once they have it? They have to have systems to standardize collection and retention, methods to permit sharing and communication between state agencies. They have to recommend evidence-based practices and standards to state and local agencies as well. So again, the idea is that these are professional data people who are coming up with best practices that they can recommend. There's also a public requirement, that's subsection E on page 6, that has to maintain a public-facing website and a dashboard that maximizes transparency so that the public and historically impacted communities can review and understand it, and develop public use data files as well. So that's sort of a description of what they have to do. The next section, 5014, you see now it's moving on to the advisory council that I mentioned. This is the body that has this policy role, this works with the division. Specifically over on page 7, talks about, first of all, who is it going to be? It's going to be 7 people. I'm on subdivision 1A now, page 7. There's 7 people on this advisory council. A person appointed by the governor who's got to have substantive expertise in community-based research on racial equity. So that's the gubernatorial appointment. And then you're going to have 6 other people who are going to be, who have to have as much as possible experience with one of those 5 situations listed there. See capital Roman numerals 1 through 5. And the 6 appointments, and so it's going to be facing eviction, violence, discrimination, or criminal conduct, law enforcement misconduct, etc. There are 5 characteristic qualities that the person should have experience with. And those appointments are made by 6 listed entities, which you'll see at the bottom of page 7 up onto page 12. And each of those entities appoints one person who will fulfill as much of those characteristics as I just mentioned. So the entities are the NAACP, the Vermont Racial Justice Alliance, Migrant Justice, Vermont Commission on Native American Affairs, and Outright Vermont.
What's AALV?
Oh, sorry, I missed that. And my memory is failing me on that. let me see if I can pull that up really quick. I think it's it's a hearing interpreter. Let me let me follow up on that. What I'm pulling up does not seem to be listing the actual names. It all says AALV Inc. I'm not getting the full.
You're muted if you're trying to speak to us.
This council, is it confirmed by the Senate or is this confirmed by somebody?
No, I think the appointments are made by the governor for one and these entities for the other. And I think AALV stands for Association of Africans Living in Vermont, I believe.
And
Okay.
if they don't have to be confirmed like every other board or commission?
I think it's like the council for the existing council for the executive director of racial equity. And that there's no confirmation process for them, I think is the model that it's based on.
You can walk right in there.
I have to say, I'm still, oh, go ahead, Dick.
Well, I think I need to get more testimony on this section because I don't quite, we're giving a government, we're allowing different private entities that may or may not be nonprofits or whatever their charters are, the right to appoint people to a state council. And then there's no oversight of who's selected.
And they're 4-year terms.
Yeah.
Which is a pretty hefty amount of time to commit. I have to say, I remain a little confused about why we're duplicating the advisory panel, because in the case of the existing advisory council, I think it is, they're advising the director of racial equity on general racial equity and social justice issues. This is an office that's dealing in hardcore data. And I don't see how it helps to have people without experience in data advising the experts, because what's going to happen is the experts will provide the data and the analysis. And then it seems to me the advisory panel won't have a great deal to do, especially since we're filling out that office with a good number of employees. So I think if there's going to be an advisory role, I don't see why RDAP wouldn't take on that advisory role in the same way that the director of racial equity, the executive director, is expanding her portfolio to include this. Why isn't RDAP taking that on? Especially since the list of liaisons to this committee, it says that each entity shall make available a person to serve as a liaison. So we're creating the office, the advisory panel, and then about 10 liaisons to work with the advisory panel, to work with the office. It just seems like a kind of duplication along the way. And I don't think you would lose anything by, I mean, obviously, if you wrote this piece of language, you're attached to it, but it does seem duplicative to me.
I agree. I mean, we don't usually set up councils, and the appointment, who appoints them doesn't bother me as much as that it looks like it's just adding another layer here, and they are people with expertise in collecting
or interpreting
data or interpreting data. So anyway, I think we should look at that a little more. I agree.
Is this something that you would talk to your committee about? It seems really like government operations.
It is. I don't know why it didn't come to us in the first place. We usually deal with boards and commissions and councils.
I don't know, it's between
I don't
you
know.
and Dick.
Yeah. I mean, we could look at it without,
If
you
you'd
know,
like.
without taking it. We could just look at it.
If you want to take it, go
Well,
right ahead.
we're happy to look at it without taking it.
Drive by.
I think.
Government Ops
it-
looked at it in the House as well, just so you know. It went to House Judiciary first and then Government Ops second.
Yeah, and it needs to go to appropriations too, and it has to be all
Yeah.
be 3 weeks.
That's right.
And I am going to, before we look at it at all, I would make I like to see a chart, you know, of how they fit together and where they are and where they come from and stuff, so like an organizational chart. So I'm gonna try and do that with this.
Plus, I'm a little nervous about setting up a data collection entity that is made up of advocacy groups.
Yeah. I mean, I noted on here when I looked at the makeup of it, I said, but there's nobody on here who
Right.
actually collects data and knows what data is collected and how they collect it, and whether it's easy to collect or not. And I saw that RDAP was involved.
As we take testimony next week on the bill, I think we should be focused on what are the duties of the liaisons, what are the duties of the council, and how is that all gonna work? I mean, I think we all agree that the need for data collection and the need
Yeah.
for analysis of that data and a better understanding of what we can do to as best eliminate systematic racism within the criminal and juvenile justice systems. And that's the goal. I don't know if this bill gets us there. So I have a lot of questions, but we're going to move to next week on that when we take it up again. But I'm going to, I assume Stephanie Barrett's aware that there's money in this bill.
Yes, as I said, it was the JFO that came up with the numbers.
I'll alert
Yeah.
Stephanie and Jane that there's this section of the bill.
It was on the sheet that Mary Hooper gave us.
Oh,
It was listed at the bottom as they already, I think, accounted for the funding on their end.
okay.
Can I
Well,
just add one last thing, Senator Sears?
Sure.
Just to tie up this last point that everyone's been talking about, which is the how the advisory council fits in. A similar discussion was had in House Gov Ops, and you may have noticed this, but the very last line of that section about the advisory council is that it sunsets in 5 years. And that's sort of how they landed, is one of the ways in which they sort of threaded that needle was to say, all right, let's see how it goes for a period of time, and we'll put a sunset on the council. Not on the division collecting data, but on the oversight council. So I think it's 5 years. 2027. I think other than that, you covered all the rest. You covered the approach.
Well, I'm on page 8, right at the bottom. The following entities shall each make available a person to serve as liaison with the council for purposes of providing consultation as needed. Number 1 is the Supreme Court. I don't know that we can do that with the separation of powers issue.
Yeah, I think that's right. And it's similar in terms of sometimes when you set up study committees, you also require a court person to be on. In a sense, you're depending on them to participate. They could refuse and make a separation of powers argument, but you could even change that to a may if you wanted. But I think that's sort of an ongoing point that you've identified accurately.
Thank you.
Oh, also a little bit of background on that, just so you know, that list of liaisons was originally part of this council. So the council had like 17 members, and those 10 plus the 7. So that became perceived as too unwieldy. So rather than having so many people on the council, they put this group, assuming that they would sort of be involved in this whole data project anyway, as liaisons rather than official members of the council.
Well, there's one thing to gather the data, and then it's how you interpret the data. And that's, I'm not understanding the connection here. So I need further information, and I'm glad the Government Operations Committee will look at this too, and particularly the makeup of the various groups. So with that said, I'm going to take a 5-minute break and then come back and do the racial covenants.